Well, good evening, everybody. I hope you can all see me and hear me clearly. Great. Well, good evening, and my name is Michael Jones. Welcome to part 2 of the Middle Temple Employed Bar webinar series entitled Applying for Silk from the Employed Bar, and as we called it, myth busting and navigating the process as an employed barrister. We've got 45 minutes allocated to this topic and to this webinar in total, so I'm keen to leave as much time as possible for Q&A at the end. I'll just begin by setting out my experience and a little bit of background in relation to me and how I navigated the process when I was appointed in 2018. And I'm delighted that we are joined this evening, and Ian are very grateful to be joined by Mr. Russell Wallman, who is as you know, the Chief Executive of the QCA, a post that he has held since June of 2013. And in fact, he previously spent many years as a senior official at the Law Society, where amongst other roles and responsibilities he had, he led the Law Society team and worked on the arrangements for the new QC scheme in conjunction with representatives of the Bar Council. So we all know that there was the previous old regime, as it were, for appointments into Silk, and he was very much involved in shaping with the Bar Council and the Law Society the system that we have now. And in fact, the first appointments from that new scheme were made in 2006. Now, a lot of the information, in fact, all the information that anyone will need for applying for Silk is on the QCA website. We know, and the heading as it stands says the award of Queen's Counsel is in fact for excellence in advocacy in the higher courts. We know that applying for Silk from the employed bar is like applying for judicial appointments, a recurring theme amongst us all. And there is a perception, if not a reality, that being a member of the employed bar, cadre of the bar, can be a disadvantage where you're practicing and the type of work you're undertaking and the exposure that you may have or may not have to judges. Indeed, there have been, as we all know, because these stats are produced every year, a consistently low level of applications and successful applicants from the employed bar. But hopefully this seminar will, we hope, assist you in how to navigate the application process and how you could apply your particular practice areas to it. So as I say, before I hand over to Mr. Wallman, a bit of background about me so you can put me into context, and hopefully I can give a few pointers as to how I applied. I'm very mindful of the fact that I'm employed by the Crown Prosecution Service, and therefore I have regular exposure and have had regular exposure to the higher courts, Crown Court and the Court of Appeal, and to judges, whereas some senior lawyers who may be thinking of applying for Silk don't have that. But we can come on to that in due course with Mr. Wallman. But I'm one of 3 practicing Queen's Counsel in the Crown Prosecution Service in England and Wales, aside from the Director of Public Prosecutions, Max Hill, Queen's Counsel. The other 2 are Philip Bennett, who practices in the Southeast, and Heidi Stonecliffe, who practices in London. I'm a product of a comprehensive school in the South Wales Valleys in Caerphilly, and I went to a polytechnic studying economics. And I only say that so that it dispels the myth that I'm yet another Oxbridge graduate who's come through from private education. I started off in Swansea in pupillage and then moved to Cardiff. And then in 2009, I was appointed as a senior Crown Advocate, the first in Wales at the Crown Prosecution Service, and I specialised in homicide and what is called serious sexual offences, rape and serious sexual offences, predominantly within Wales. And then in 2016, I was encouraged, I thought about applying for Silk, I hadn't thought about it too seriously, but because I thought, well, it's not something that people with my background necessarily would get. But I had some support from some of the judiciary, and in 2016 I made the application. I had the support locally from senior management, and put the application in. Now, as most of you are aware, when you look at the process online, you have to give a description of your practice, and then you have to fulfill the various competencies, which I'm sure Mr. Wallman will touch upon, which is understanding and using the law, working with others, oral advocacy, and written advocacy. And in fact, looking at the competency framework, the panel, it says, will be looking both at the written and oral aspects of advocacy. Oral advocacy includes advocacy in a court or tribunal, mediation, arbitration, or negotiation. And on that point, I think it's the obvious one, which is to give specific examples. There can be a tendency when filling in forms, particularly when one deals with leadership or working with others, to use sort of general sweeping statements like, I'm at my best when I'm leading a team, or I thoroughly enjoy working with others and encouraging people from all backgrounds. Well, these are, as we all know, pretty sweeping statements. But what I know that they're looking for are precise examples, so that if you say that you work with others, give an example of how you worked with others, how you solved a problem. And one of the things I would suggest, just as a piece of advice, whether you take it or not, it's just my experiences, is whether you're thinking of applying next year or whether you're thinking of applying perhaps in 2 years' time, is to have a book, or in these days have a folder open on your computer, whereby whether you're doing cases in the court, the county court, or in arbitration, in a tribunal, or in negotiation, is to open up a folder and make a note, just a brief note, of the case that you were doing or that particular issue you were resolving, the name of the opponent you were against, or the senior manager involved, or the judge, and then make a note of any particular points with a view to, with an eye on the competencies they're looking for, so that when it comes to it, and when you do apply, rather than within the short window that you have to apply for Silk, so next year it may be February to April, so you only got 6 or 8 weeks or so, you will have with you a folder showing who you've been against, the kind of cases you've been doing, so that you can develop those. But as I say, because they will be looking for precise examples of how you fulfill those particular competencies. Then it's a question of assessors, people who will support you. And again, I know that this is a somewhat contentious area, because some people, as I said at the start, may not have access to many judicial referees. But certainly back in my day, there were 8 judicial referees. That's changed now, I think. And there were 6 opponents, people that you've been against, who the panel from the QCA can draw from to get an assessment as to how you were in that particular setting. And then there's the 4 what are called client referees. And obviously, if you're a defense advocate, you can go to solicitors. But clearly there are, within the framework on the website, allowances made for people who, in my case, just prosecute, or for people who are not within the traditional chamber structure, and who you could draw upon. The only advice I would give, again, maybe an obvious one, is that if you are, when you do seek out your references, whether people have suggested you apply or whether you are thinking of applying, is to try as best you can to see them face to face. I'm still amazed that people will put down a reference or a referee on a form and not even speak to them and ask them, which seems to me to be crazy. You want to see the whites of their eyes, as it were, speak to that person and say, would you be prepared to support me if I applied for Silk? You don't want to just necessarily rely on an email. I know it can be difficult, particularly in COVID, and a lot of it will be telephone calls and emails. But don't just put somebody down. In my advice would be, don't put a reference down who you haven't spoken to first. And then you list the 12 cases within that framework that you have done, cases of substance that they're looking for. over the last 3 years. I think that may change now and be extended. Mr. Wallman can tell us about that, because obviously we've had the last 9 months of COVID, and you have to demonstrate those competencies within those cases that you've done and within the framework. And again, making sure that you've got your examples as to how you can apply those particular competencies. I then put the application in, paid the application fee, which then I think it may still be about £2,000. And then you wait. And then I was told I had an interview. I was selected for interview, and I went to a fairly nondescript. It's very James Bond. You're told not to arrive before about 15 minutes before your interviews, to stop you lurking around and possibly seeing other people, because it is a confidential process. And then I was interviewed by 2 of the panel, one lay and one legal. In fact, in my round, it was the legal interview was Dame Janet Smith, a former Lady Justice of Appeal. And that interview takes place over about 40 minutes. And best advice I can give for your interviews: make sure you know your form, make sure that you know the examples that you've given on that form. Maybe have 1 or 2 examples in reserve in case you're asked about, give us another example about how you worked well in written advocacy. And the interview, as I say, can last anything between 30 minutes and 45 minutes. And then that's it. You're told that they'll let you know. And it was an email then I received on the 14th of December in 2017, when I'd just come back from court, saying that, and that's when you find out whether you've been appointed or not. And I was very fortunate to get that letter to say that I had been appointed. In my year, going back to the point about employed barristers, there were only 2 of us appointed in my year. There was myself and a gentleman by the name of Nicholas Khan, QC, who worked and still does work at the European Commission Legal Services. So again, there were only the 2 of us out of the entire application process that were successful. And then the ceremony takes place, a bit of light-hearted relief now. Just that was in Westminster Hall in February, a few months later, where you go along to Eden Ravenscroft and pick up all the fancy dress, as it were, and the full bottom wig. And I have to say, as a boy from Caerphilly, I never ever thought I would be getting advice from my mother on how to put tights on. But there it was. We went along to Westminster Hall, and it was a superb day for the family. And then I carried on practicing then back in Wales, as I say, predominantly in Wales, in north, west and southeast, in leading now in cases of homicide and cases such as that. So that's effectively my background and my how I approach the application process, so that you can put that into context. As I said, acutely aware that many from the employed bar don't have regular access to courts or tribunals. But that, I hope, helps to put into context where my background and how I approach the application process itself. So we're 15 minutes in. So as I said, I'm very keen to bring on the star of the show, as it were, Mr. Wallman, and to leave sufficient time for questions and answers today. So without further ado, I'll introduce Mr. Russell Wallman from the QCA.
Thank you. I think the description there of the application process is little changed from there to now. The one change that I should mention is that it's not quite as easy as it used to be to make sure that you only list assessors who you've already contacted. The system now asks you to list your 12 cases of substance as the best evidence of you meeting the competencies, but you're expected to list a judge and a practitioner from each of those cases. Obviously, if you do something which looked like being a dispute but ended up being settled, then that's a good reason for not listing a judge. And if there wasn't another advocate in the case, that's a good reason for not listing an assessor. But not having contacted them or being afraid that they might give an unfavourable assessment wouldn't be a good reason. There were 2 main reasons for that change. One is that although, of course, every applicant wants to make sure that the evidence before the selection panel is the most favourable it can possibly be. From the selection panel's point of view, the most important thing is to get the most accurate picture of each applicant it can. It really doesn't help the panel, although it might help the individual, if it has a distorted, unduly favourable view of the practice. And so it was quite deliberate that there was less choice in terms of which judges people can list as assessors. The other reason was that although, as has been said, most people would not choose to list as a potential assessor somebody who they didn't know was keen to give them an assessment, we discovered, and it's been reinforced from a number of sources, that some applicants, and in particular some women applicants, were very hesitant about approaching High Court judges to ask, if you like, before putting them on the form, will you support me if I put an application in? And so removing part of the incentive to do that by creating a situation where you had to list the judge anyway once you listed the case was worthwhile from that perspective. But that's the only significant change in the process. We still hope that even this year people will get the outcome before Christmas, although that's out of our hands. The selection panel's recommendations have gone to the Lord Chancellor on the normal timetable, but whether they will be able to process them in time, we don't know. The main thing I would want to say about the process as a whole is that it is specifically a scheme for advocacy. It's designed primarily to identify the best advocates for cases in the higher courts of England and Wales. It's not a scheme for excellence as a lawyer in general. So solicitors who may be brilliant litigation lawyers will not be effectively eligible to apply. Similarly, whether as an employed barrister you're well placed to apply depends entirely on what sort of work you do as an employed barrister. If what you are is general counsel to Shell or whatever, then you probably won't be well placed, because you're unlikely to be doing contested advocacy of that sort. If, on the other hand, you're in the CPS, or if you're an employed barrister acting as an advocate in a solicitor's firm, then you should be at no disadvantage compared with barristers at the independent bar. There is an argument, I know, for widening the scheme or for recognising other forms of excellence as a lawyer. There is, of course, the honorary QC scheme, although that only appoints less than a dozen each year. There is an argument for having, if you like, either an expansion of the QC scheme or a parallel to the QC scheme, which did recognise, following the same sort of application process, excellence in other areas. That's essentially a question for the professional bodies. It's the professional bodies who are responsible for the design of the scheme and for proposing any changes to it. They need to get the changes signed off by the Lord Chancellor, but the initiative very much rests with the Bar Council and the Law Society. It is true that there are comparatively low numbers of applications, both from employed barristers and indeed from solicitors, although it's even starker in the case of employed barristers. On my calculation, there have only been about 60 applications from employed barristers and fewer than 20 appointments of employed barristers in all the time since the new scheme opened in 2006. Although I think I'm right in saying that before 2006, employed barristers weren't even eligible. The position for solicitors is superficially better, but although not hugely so, there's never been more than 6 solicitors appointed in a single year. Almost all the solicitors who are appointed have been people who act primarily as advocates in arbitrations and primarily working for the big city firms, and some of them indeed working overseas for the big city firms. I think there probably was a time when there was, certainly at the bar and to a degree amongst judges, something of a prejudice against employed barristers. There were people who you heard say almost that if they were any good, they'd have cut it at the independent bar rather than going into employment. I think that attitude has certainly changed amongst the leadership of the Bar Council, and there's certainly no trace of that on the selection panel at the moment. You do very occasionally see it, a suggestion of that in an assessment from a practitioner or a judicial assessor, but I would say it's become considerably rarer even in the 6 or 7 years that I've been working at QCA. So I don't think there is any longer a prejudice of that sort. There is, though, and it's difficult to escape this fact, a difficulty for most employed barristers in demonstrating the advocacy experience. The advocacy in this context means helping to resolve a dispute or a potential dispute. Few employed barristers spend most of their time doing that. Indeed, one of the reasons that a number of barristers become employed barristers is that they prefer not to spend all their time doing that. But there's no disguising the fact that whilst that remains the case, and whilst the definition of what's required for appointment remains the case, it is going to be difficult for very many employed barristers to succeed. I would echo what was said about preparation. The application form, we carry out a survey of applicants each year, and almost everybody reports it taking more than 32 hours, which is effectively a working week, to complete the application form. It's not something which you can decide in the middle of February, oh, it's a good idea to have a bash this year. You will find it much easier, everybody tells us, to do it if you keep the sort of record that was discussed going back over years of cases which you think will help demonstrate one or other of the competencies. That, of course, can provide a good opportunity to mention to a judge that you're thinking of applying in the near future, and would they be happy to be an assessor if you did so. You know, if they say something like, I'm not sure that's the best example to choose, that probably tells you all you need to know about whether they're going to be a favourable assessor, and you might well think about providing a different case instead. But that sort of preparation of the application is, I think, crucial if you are going to list cases which give you the best chance of success. It's also true that when it comes to the interview, and about 2/3 of applicants get an interview and about 2/3 of those are recommended for appointment in most years, that for a number of people that's going to be a brand new experience. It's perhaps less of a brand new experience for people in large corporate organizations. So some employed barristers will find it less unusual than some people at the independent bar, but that sort of competency-based interview doesn't necessarily come naturally to people, nor does the question of blowing your own trumpet, and I'm not doing it to an excessive degree, but you know, making clear what you did rather than what the team did is important to get across to the panel the individual applicant's contribution. And I would strongly advise anybody interviewed to try to have a practice interview with somebody they know who was relatively recently appointed. That somebody in that position will be able to look at your form and know what sorts of questions you're likely to be asked and help you to frame your answers in a way which gives the best impression to the selection panel. There's no getting away from the fact that the interview is of some significance. It's not nearly as important as the evidence from assessors, but it is of some significance. And you can't expect to just wing it and make the best impression on the selection panel, knowing your own application form, knowing how you will demonstrate particular things which the competency framework makes clear the selection panel is looking for, is important, and trying to think of that on the spot when the question comes up, rather than having given it some serious thought in preparation, would be a mistake. I think the only other thing that's worth saying at this point is that your most useful mentors, in my view, will always be people in the nearest situation you can think of to you who have succeeded in the past. Perhaps especially, although you may not know this, people who didn't succeed at the first attempt, but who subsequently succeeded. They will, the process hasn't changed to any significant degree over the last several years. And so somebody who was appointed in any time in the last 5 years will be able to give any aspiring applicant a good sense of what sort of things are likely to come up at an interview, and what sort of things, with the benefit of hindsight, they think were useful in their selection of cases and assessors. Unless there's anything else you particularly want me to cover, I'll leave it there to leave a little more time for questions.
No, that's perfect. Thank you, Mr. Wallman. That's great. Right. So I think Oliver was going to give us some questions that may have been provided to us in advance. I haven't got those on my screen at the moment. I don't know whether, Oliver, you can get them to me. Can I just ask, while we're getting that on the screen, I just want to ask one thing, because one of the things that does recur, a common theme, as it were, is looking at the competency framework. Mr. Wallman, if you can help us with this. It says, in terms of oral advocacy, written and oral advocacy, it says the panel will be looking both at the written and oral aspects of advocacy. Oral advocacy includes advocacy in a court or tribunal, mediation, arbitration, or negotiation. A, does that still apply? And B, how does an applicant get an assessor from those? Because somebody who's involved in negotiation or arbitration isn't necessarily going to be in front of a high court judge. So how would that work, do you think?
Correct. I mean, negotiation here means negotiation to end a dispute, rather than, if you like, a commercial negotiation about the terms of a lease or whatever. That would be, that's a situation. I mean, I said that it's not required to list a judge if there wasn't a judge in the case. So if, I mean, there's no point in listing the case unless you can get useful evidence from it. But in the example you gave, there may well be a client who was very impressed with you, and a practitioner, perhaps a practitioner on the other side, who can also attest to your excellence. So in that situation, you're welcome to list the case. You'd list a practitioner assessor. You might well list a client assessor. You wouldn't list a judge simply because there isn't one. It would be foolish not to give the selection panel a decent selection of judges. So, you'd want there to be half a dozen judges. But if it so happens that your practice contains a high proportion of cases which, although very complex and potentially very serious litigation, got settled, then there's no reason why you can't list a number of cases in which there isn't a judge for precisely that reason. There will still be assessors who can give, legal assessors, including legal assessors, who can give strong evidence of your competence.
Great. Well, I've got two questions here which I can ask. I know there are a few people who want to jump in, so we can go on to the Q&A proper then. But if I can just read these two out to you, and maybe you can help here. One from Michael Butcher, who's the chair of Gray's Inn Employed Bar Working Group. And he asks this, what is the thinking relating to assessors for CLO/GC, whose role is largely to steer their client away from the courts through excellent legal risk analysis and legal advice, enabling the business to go forward lawfully and ethically?
I think the short answer is this isn't the scheme for you at the moment. Right. That sort of excellence can be recognised through appointment as honorary QC, although, as I say, there aren't very many of those each year. But by the sound of it, that's not a role in which you would have any significant advocacy. And the point is not being employed or not employed. The point is being an advocate. And as you know from your personal experience, advocates in the employed sector can and do get appointed, but it's advocates who get appointed.
I think that's right. We've also had, I know people who are self-employed, for example, in chambers, who are maybe doing certain commercial work. They have that similar question as Mr. Butcher's had, because a lot of their work is advisory, and in fact going to court would be seen as a failure rather than a chance to demonstrate excellence. But there we are. Second question from Mark Wright. I have been an employed barrister for almost all my career since 1997, engaged in non-contentious matters and advisory work. More recently, I've held senior roles and head of legal positions. Am I at a disadvantage to other applicants applying from the employed bar because I've chosen not to pursue litigation as a practice area? And if I am at a disadvantage, is there a plan to recognise excellence in candidates who've chosen the same career path as mine? So I suspect it's the same answer as before, but if you can just touch on that.
It is the same answer as before. There is clearly a good case for there being a scheme beyond the honorary QC scheme to recognise excellence in other aspects of being a terrific lawyer. But this isn't it. This is about advocacy.
We have a question. We'll go live now, if that's all right, from Master Helen May. I think if we can, Oliver, if you can facilitate a question from Helen. Can we hear you, Helen?
Can you hear me, Mike?
Absolutely, great. And I can see you. Fabulous.
Excellent. I can see you as well. Well, it's two comments actually. I was representing the employed bar. I was on the bar working group in 2004-2005 that looked at reform of the silk system, and I fought very, very hard for alternative forms of advocacy that weren't litigation and court advocacy to be included, and I failed, I'm afraid. Mr. Wallman, I completely agree with you what you say. It was not deemed, certainly the powers that be at the bar and those at the whatever it is in the Civil Service, Judicial Appointments Commission, whatever it was called, did not feel that advocacy outside the courtroom could be recognised by the silk scheme. I don't agree with that. I was general counsel of a FTSE 20 company for many years, and as one of our other speakers has said, my job was to keep us out of court, advocacy in the boardroom and in other areas was extremely important, but not in court. That wasn't recognised. So it's very unfortunate. The only other comment, if I may, Mr. Wallman, to you, that sort of always irked me slightly, you referred to the independent bar, meaning effectively the self-employed bar in chambers, rather implying that if we're employed, we're not independent. I'd much prefer if it was looked at as self-employed and employed, not independent and employed, which rather it sounds as if we're not. Some of us were really bloody minded and still are in our careers, and we're employed to be independent minded. So could we sort of ban the independent bar versus the employed bar, please? Because it does irk some of us, if you don't mind. But thank you.
I agree with you, and I apologise. I was wrong.
Sorry, I'm only saying it light-heartedly, but my blood pressure
I do agree with you for exactly the reason you give.
Well, I think if you needed any evidence of passionate independence, you had it right there. All right, and it's a very good point, because that is something which I think we are with the bar generally, and the Bar Council encouraging a one-bar approach. And so we have self-employment and employment, but we all retain our professional ethics and our independence, whether we're working in commerce or in chambers or in government. So that's a fair point. I can't see the whole screen of everybody. I wondered whether are there any other questions live. Anybody wants to put their hand up, and Oliver can come to you because he's got a better scope than I have.
There's no one raising their hands at the moment, Mike.
Can I raise a question then as well, and just in relation to that point? Are there any moves at the moment? You said at the start that any issues as to the current system need to be addressed with the professional bodies, so the Law Society and the Bar Council, rather than necessarily with the QCA. Are there any moves at the moment in the foreseeable future to consider amending or tweaking the process that would allow not just the existing competency frameworks, but allow an addition or an amendment so that those people who perhaps don't go into court or arbitration as frequently as that could still put in an application?
There aren't, to the best of my knowledge, any current plans on that. I wouldn't want to give the impression that you have to be in court or arbitration all the time,
No.
but there has to be enough evidence of contested advocacy. So, you know, if you haven't managed to get sort of half a dozen cases of decent substance over the last 3 years, then it's probably not enough. But
No.
you don't have to be in court in the way that a criminal barrister is in court. Of course, quite a number of people at the self-employed bar, depending on their area of practice, aren't in court all that often. You know, revenue law people are often not in court. PI and clinical negligence, they're also not in court, but of course they do have the mediations which provide evidence of advocacy, so that's not quite the same thing. But so you don't need to be in court all the time, but you do need there to be enough to get evidence of your excellence in oral advocacy. Can I just say, in case I forget at the end, that if people have any questions that they want to ask outside the meeting, they're very welcome either to call me or email me at QCA. And we are at the moment at a blissfully quiet time of year, having just got our recommendations to the Lord Chancellor. So it'll be no trouble to reply to anybody who has a question.
Well, that's very kind of you. Thank you very much, because I know that this is an area, as I said at the start of this seminar, that a lot of employed barristers feel quite passionately about. Not just judicial appointment as a separate topic of conversation altogether. And there are certain, again, hurdles that are sometimes seemingly put in the way if you are employed as opposed to being self-employed. But from the perspective of employed barristers, one other thing as well, I don't know whether your views on this, an industry has grown up around applications whereby there are people who will, for a fee, advise you on your form and advise you on your interview. Now, I didn't utilize that principally because I couldn't afford it. But what's the general view from your end as to people employing the services of professional interview and application form advisors?
Well, we wish it wasn't necessary. I mean, we don't think it is necessary. We wish that people didn't think it was necessary to the extent that they do. But, you know, you do have to recognise that especially people at the self-employed bar, this sort of application process will be new to them. It's not the sort of thing they've done in their career, especially the ones who joined before there were the more organised systems of pupil recruitment and so on. It is, as I understand it, very expensive. When we surveyed applicants as to whether they'd used it or not, it appeared to be marginally linked with success in terms of getting an interview, but not in terms of succeeding at the interview. I think it's more likely to be of, I can understand people using it if they don't have a colleague or a friend who's been through it before. I would say that if you have got someone like that, they're likely to be more used, substantially more used, because the people running the consultancies don't have any recent experience of the system. I mean, one of them advertises his role, which was some 6 or 7 years before I had a role. I think he had a minor involvement in the first year of the new scheme and nothing since. You know, the self-assessment is not by any means the most important part of the process. The most important part of the selection process by some distance is the assessments from assessors. And the second most important part is the performance at interview. The self-assessment is more useful, if you like, in providing a quarry for possible questions at interview than it is, it's not something that's just marked. Apart from anything else, the selection panel can never be sure who's written the self-assessment. You don't know that the applicant has written it rather than the consultant. So it is easy to overstate the importance of the self-assessment. Having said which, thinking carefully about which cases will provide the evidence, the best evidence you need, is obviously useful, but you shouldn't need an external consultant for that. And preparing for the interview is important. But again, if you have got a colleague who's been through it recently, that's likely to be more useful than one of the consultants.
Well, that's great. And I think, well, that's very useful because, it's very important that people don't just march into assuming that some independent advisor is going to be the be all and end all for it. I think before I hand over to the rest of the participants here, in case there are other questions, I think one point that's important to make from an employed bar perspective is that we are, by very nature of what we do, a very diverse group of people in terms of social mobility, ethnicity, and all other characteristics, and BAME. And I think it's very important going forward. And this, as you say, Mr. Waldman, is probably best done by the Law Society and the Bar Council, is that in terms of future senior advocates and future judicial appointments, that there's the greatest pool that they can draw from in terms of diversity, and the employed bar is a massive part of that.
Yeah, and social mobility, as you gave your own example of being coming from a non-traditional background.
Absolutely. I think there is a question. I think, Oliver, I think it may be from Sarah. I don't know whether we can facilitate that.
Hello, can you hear me?
Yes.
Thank you. Mr. Walkman, thank you very much for giving up your evening. That was very interesting. I'm a partner in an American law firm. And I have said one of my concerns about the QC system, and I'll declare into I am married to a commercial silk, is that I question whether or not the system we have at the moment is in the public interest. Not just the diversity, but also whether it's recognizing the right things. And I understand, of course, that you have been given this remit by the profession. Were there to be changes to the system such that legal excellence in any context were to be the only and the sole criteria, and effectively the sort of system that you currently have in place for honorary silks was to be the standard for everybody, do you think there would be insurmountable logistical problems in running the system? Do you think that it's supposed to be a self-financing system? Do you think you and your team would still be able to manage?
Well, obviously, you would expect the method of assessments to be rather different because, to take a very obvious example, if people don't appear before judges, we can't get assessments from judges on them, and that is the single largest part of the process at the moment. You could certainly devise a system which would cover that. I imagine what you would do is, if you like, divide your legal excellence scheme into various chapters, if you like. One of them would no doubt be the QC scheme, which would be the higher courts advocacy scheme, and another one might be commercial litigation, and another might be excellence in general counsel or whatever. I think you'd need probably to devise bespoke assessment methods for each, and you'd obviously need to decide whether the current selection panel was the right panel for each, whether you needed three different panels, assuming there were 3 schemes, or whatever. So it's clearly not an impossible thing to do. It's perfectly possible to identify medical consultants in various different fields, and I presume that you don't expect a consultant gynecologist to know exactly the same as a consultant brain surgeon. So I don't see any reason why it isn't possible. To the best of my knowledge, neither professional body is pressing for that at the moment.
Yes, they may not have heard from us all quite yet.
Absolutely.
But, I was wondering also, from your expertise in running the system, obviously it takes a lot of judicial time to fill in these applications. And of course, employed barristers would not probably be taking up that time. But other referees, such as the ones you have in the honorary QC system, do they generally provide the same sort of assessment forms, or is there a different system for those?
We don't do the honorary QC scheme. I used to work on that when I was in the Law Society, but at which time it wasn't quite the same. But I think it may have moved on, so I wouldn't like to say exactly how it's done now. Yes, it's true. The assessments take a considerable amount of judge time, and some High Court judges are asked for half a dozen in a year. You know, on an optimistic basis, they'll take them an hour or 2 hours per applicant, assuming the judge has the information they need to hand. It's a constant slight surprise and great relief to us that they're so willing to do it. And I think the reason is that the judges still think that the scheme is really important and important both for the justice system as a whole, and indeed, they think helps make the judicial task a little easier. But yes, it's very time consuming.
Thank you, Sarah, for that. There's a question from Patrick. I think he's posing a question here. I don't know whether you can ask it, because it's almost giving advice. But Patrick Rappo is saying, I'm a partner in a law firm specialising in criminal law. I was considering making an application for SILP next year, but based predominantly on written advocacy, i.e. preparing legal arguments for the Court of Appeal. However, on the basis of what Mr. Wallman has said about the need for oral advocacy in front of courts, and mine being from over 5 years ago, am I correct in the view that there's virtually no point in applying? I'm not asking you to give him advice on whether he should apply or not. That's not your remit. But what Patrick's point there is again, and I think you've touched upon this, if not dealt with it, Patrick's predominant role is working for a high-profile law firm offering advice and written advice, written advocacy on very high-profile serious cases, but would have very limited oral advocacy experience. And again, can you just comment on that?
I think it's going to be very difficult. If his oral advocacy experience is all from 5 years ago or longer, I think it's going to be very difficult. You know, if he was in court even sort of 2 or 3 times a year in significant cases, then if the evidence was good enough, then that would be sufficient. But if you're talking about no evidence of oral advocacy within the last 5 years, then I think it's going to be very difficult, to be honest. And we're finally, not so desperate. We're not so desperate for funds that we need to encourage hopeless applications, and that would be hopeless on technical grounds, if you like.
Yeah, well, I think again, just before we close off this, it is that I would personally recommend that before anybody does anything, firstly, you very kindly, offered your services in terms of an email to clarify any points. Obviously, you can't give people advice on the strength or otherwise of an application, but you can certainly clarify matters. But I would advise anybody who's thinking of applying to really read through all the information on the QCA website, because it really does spell out the various competencies and the allowances that can be made in certain criteria and some of the frameworks. So I would certainly advise that. On an aside, you may not know the answer to this, but how does somebody apply for, or indeed be recommended for, an honorary QC award?
The Ministry of Justice invites applications usually in the summer of each year, and it's helpful, obviously, to have supporters. You can apply just off your own bat,
right.
But the way you're going to get it, if you get it, is going to be that some significant people, ideally a sort of presiding judge or whatever, or somebody, I'm trying to think of where else, somebody within the profession can often, the selection panel includes representatives drawn from the Bar Council and the Law Society and the law teachers and so on. So support from that sort of area is helpful.
Right. Excellent. Well, it's now 10 to 6, so I think we'll need to crawl off here. I'm very grateful to you, Mr. Wallman, for your time. Thank you very much indeed for joining us. I know that some people will be heartened and others disheartened by it, because as you spelt out what the criteria is at the moment, and obviously people who feel strongly about it have to take any representations they have to their professional body. But I'm very grateful for your time. I know that you now have to disappear off screen, as it were, so I won't invite any more questions for you. But Oliver, am I right in saying that we can hang on for another 5-10 minutes if people want to ask questions amongst themselves?
Absolutely.
Okay. Well, again, I'd like to thank Mr. Wallman on behalf of Middle Temple for his time and his very kind information and advice that he's given us this evening. Thank you very
welcome. You're very welcome, and I am happy to deal with individual questions as well, at least until March.
Great. Thank you very much indeed.
You're welcome. Bye.
Bye-bye. Right, so there we are. Thank you, everybody, for joining us tonight. I hope, whether you are heartened or disheartened, as I've said, I hope that that was informative, at least. It is the position, as we see Mr. Wallman disconnecting himself from the group, that I'm very grateful to him for his time. As I reiterate, there's a lot of information on the QC website for those who are considering an application, and they are generally very helpful in the way that they can offer advice. I think what we get from that today is that the system itself is very much geared towards oral advocacy in court, that clearly there are other competencies which members of the employed bar would probably, I think, outshine some members of the self-employed bar in terms of working with others, in terms of written advocacy, in terms of diversity. But that's where we are at the moment. Helen, do you want to jump in?
Yeah, I see there's some things on the chat going on. Can we get the Bar Council in? Can we lobby the Bar Council to change this? I spent a lot of time 15 years ago trying to do that. To be totally frank about this, the Bar Council don't want to let non-court advocates in. They're worried about a lot of solicitors, I think, and other people applying for silk, and they want to keep it more as a tight shop. I got absolutely nowhere with it. I mean, maybe 15 years down the line, it is worth taking up again. But it was a lost cause when I fought it all those years ago. We can have another go with it, and if people want to talk about that, I'm sure that we can think about that as a working group. But I think there will be a lot of resistance from the Bar Council on this, despite all the arguments that have been put forward. And Sarah, you obviously said some good things on that, but I don't see personally any great enthusiasm for change. But that's just from my perspective. I thought I'd make that because a lot of comments just got on the chat.
Mm. Yeah, no, I think that does seem to be the prevailing view at the moment. I think that they're saying that if you are somebody who isn't going to court as an advocate, then it's a bit difficult then to shoehorn yourself into the current system. So, I mean, I think that's something where maybe the employed bar committee can think about. And I think the inns can think about themselves, but I think you're right. At the moment, the position seems to be as it was when you were fighting the corner back then, Helen. Does anybody have any points to raise while we're here, just from their own particular standpoint or their own experience? No.
We've got Heidi, who is actually on a member of the Bar Council and can possibly either just say she's going to raise something, or she can elaborate a bit more on that.
Yeah.
Hi, Mike.
Hi.
Yeah, I put some comments earlier on when Russell was online, and I would say, just as an aside, if anyone didn't read it, I did actually take advice from the QCA when I was applying, and I in his assistance, and the advice that he gave, and as it turned out, it worked out well, because I was successful this year. But I am on the employed barrister Barristers Committee, but I'm also an elected member of the Bar Council. I know there's a Bar Council meeting coming up, not this coming Saturday, but I think in a couple of Saturdays' time. Mike, I know that you're on the Employed Barristers Committee. We could perhaps table a question that we can put to the Bar Council about that. I didn't think it was right to sit here as an elected member of the Employed Bar on the Bar Council and not offer some sort of assistance. How far it gets us, I don't know. It may well be that there is a separate scheme that needs to be set up rather than the I'm just offering that out there now. Well, as I say, firstly, Russell Warman, exceptionally helpful, and if there's anything I think happy to try.
Yeah, I think that's a very good point, and that's one that Ian's made on the chat, I think, as well, which is about the fact that if there is resistance to amending the current system, whether or not there's the option of having I mean, their argument will be, well, there is already a second system, which is honorary causa, Queen's Counsel, for people who are not active advocates in court, and that there is that particular avenue for people to take. Patrick very kindly sent me Backfee's response to, I think it was Patrick can probably elucidate on this, but there was certainly recommendations made about how it could change, which was sent on to the QCA. I sent that on to Mr. Wallman. But again, I don't think from what we're hearing, we can certainly, as Heidi said, table a motion to see whether or not this can be revisited, since Helen did her best efforts 15 years ago. But Patrick, I don't know whether you can elaborate on that document.
Well, it's a sort of common theme with a couple of the documents that Backfee had submitted to the QCA, which is effectively saying that the definition of advocacy, one should include simply written stuff, which is part of the reason why I wanted to ask Russell that point in relation to just basing an application on written advocacy. Certainly on my reading the papers, you could make an application with just excellence in written advocacy, because advocacy is broad enough to encompass that. But Russell's view is that practically you do need oral advocacy, which is, I think, a step backwards from what I'd understood it to be previously. But the position in the Backfee paper was one that we sort of issued in a couple of other consultations. Yeah. Is to effectively say that the definition should be broadened to excellence in lawyering, effectively, as opposed to just excellence in advocacy. But it was a specific consultation about, I think, broadening what information you could get from referees. So it wasn't directly relevant to the question that was being asked, but it was just another Backfee consultation response, putting forward that point about expanding the advocacy.
Yeah. No, well, thank you, Patrick, and thank you for sending that to me, because that was an interesting document to read. Okay, well, as I say, I hope at the very least this has been an interesting seminar. I know it is important to a lot of members of the Employed Bar, as I said at the start, such things as judicial appointments. I think we find certain hurdles put in the way there. In certain circumstances, but I hope that you all found this very useful, even if you found it slightly disappointing. But I think now we've heard it from the horse's mouth. I was very keen that we had Mr. Wallman as part of tonight, because there's sometimes a tendency that we all talk to ourselves, to each other, about these kind of issues. And I think it was personally important to get clarification from the Chief Executive himself, as I said, whether you were encouraged or not by what he said. And then obviously you can reflect on what's gone on tonight. If you are applying and you feel in a position to apply, I hope that some of those tips have been useful. But at least we know where we are, and then we can determine, either as a working group within your respective inns, or in the Bar Council can determine to what degree you want to take this forward. All right. So I'd like to thank everybody. I'd like to thank Oliver for being the administrator, for sorting everything out, and the Inn for facilitating this, for Middle Temple, facilitating this evening. I know most of you on screen, so I hope very much to see you in the near future, and thanks very much for joining it this evening. All the best.